Hello, students. This is the video lecture on privacy for JMS 494. For the little interstitials this time, I'm actually going to take a video. I made this video a few years ago. I went to see some like really lowbrow. It's professional wrestling, but probably the bottom rung of professional wrestling. I went to see professional wrestling with my son. I'm going to take that video, chop it up, and put it as interstitials. But anyway, and you'll see later why I chose wrestling for this. Are you going?
Yeah.
Okay, it is Saturday, February 4th at 6:20. I am driving with Imran to go see some wrestling. I hope it's weird. I hope it's something unusual. I hope it's fun. Anyway, I was walking yesterday coming out of a comic shop. I saw this flyer. I normally ignore that kind of stuff. Lo and behold, I paid attention. The date of the wrestling event is tonight, so we're going. You excited, Imran? All right, here we go. Okay, we just pulled into the parking lot. It looks even lower rent than I thought. Imran, what do you think? You shaking his head no? What did you say before we parked?
Is this for like little kids or something?
You think it's like a little kid's boxing?
Yeah. I don't think this is for grown adults to go to. This is something for little kids.
Well, we've already spent 15 minutes to drive here, so we're committed. We're in. There is no absolute right to privacy spelled out as such in the Constitution. Most people point to the Fourth Amendment as the place where the inspiration for the right to privacy derives from. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall la da da da. So from this Fourth Amendment, the right to privacy has been extrapolated, and it's always undergoing some type of debate. Here we have an image here. This is the kind of thing that is a privacy concern made possible by new technology. It's a some guy made an app that was a Taylor Swift flight tracker that indicated where Taylor Swift was, where her jet was. And the person's claim for publishing the information was that it's all publicly available on flight logs and things. And they wanted to kind of point out the hypocrisy that Taylor Swift said, you know, she's being all environmental and green and saving the planet, and kind of pointing out, hey, every time you fly somewhere in your private jet, here's the amount of gasoline and all the CO2 emissions. Anyway, I just put that up as an example of the kind of challenges that new technology presents for privacy issues. Okay, even though there is a constitutional right to privacy, as with other areas of the law, things are really ambiguous. And there's a lot of variations. Courts have found that searching a public employee's desk and filing cabinet is not a violation of their privacy. Now, this is public employees, rather, public employees. I've already mentioned that new technologies present new challenges. There's also those things like those smart speakers that are in your home. Those things are recording. Apparently, they're recording or can record all the time. What's the limitation as to when authorities can get those recordings? And then we have CSLI, cell phone site location information. Basically, it's geographic information as to where you are based on the traffic from your cell phone. I think most of y'all know that when you're using a cell phone, it's always pinging, sending signals off of local towers. So based on your cell phone traffic and your cell phone history, they can track where you are. The courts have said that that's not public information, and the police need some type of search warrant or probable cause or a subpoena. It's in the textbook. That's not publicly available information. Police have to get some sort of permission before they can access that information. All right, the textbook is organized around different categories of privacy law. We have intrusion, false light, appropriation, or private facts. And the status of the intrusion torts, like everything else, varies depending upon what state you live in. I'm of the confident belief that all of us are going to get great jobs, maybe not in California, maybe not even in the United States. So wherever you are living, if you find yourself lucky enough to be doing professional media work, you should find out the status of the laws in your area. Spring Valley Gymnasium, there was your standard wrestling ring. There were about 3 or 4 rows of seats set up on each side. Altogether, there was probably 20 people wrestling in the time we were there, including faux managers. Most of the matches involved like 3, 4, 5, up to 6 people. fighting. Most of the guys were pretty out of shape. I got the feeling that I could have gone out to my car, put on some tights, and jumped back in the ring, and I would have fit right in. And there was only a handful of guys that were stereotypically muscular. I bought a hot dog, but they actually did not have any condiments for the hot dog. But the lovely young woman who was working behind the concession stand put some nacho cheese on my dog. Take a look at this phrase, intrusion upon seclusion, as the textbook says. We have, once again, we have this concept of the reasonable person. If a reasonable person has an expectation of privacy, that there is privacy. However, there are certain exceptions. Having discussions after an automobile accident and like what is newsworthy and what is not newsworthy, what is in public, what is not in public. There are some gray areas, but in general, you should expect people's privacy. Now, false light, I'm not going to say much about this because I don't even understand this. To be honest here, false light is so close to libel that the libel defenses that we've covered in another video lecture could also apply if you are accused of this privacy tort of false light. I don't understand the difference between false light and libel, okay? So I'm not even going to ask you about that. Just know what it is. Okay, now we have appropriation, which includes commercialization and the right of publicity. The lecture slide says they differ in two very important ways. I don't even know off the top of my head what those important ways are, so I'm not going to ask you to know that stuff. But just take a look at the textbook. It's on page 262, page 262 and 263. It's probably worth reading about at least once. What is the difference between commercialization and right of publicity? I will say, though, that actors do and should have a ability to control their image and likeness even after death. And that's where it gets very confusing, is this after death that we have these individuals who've been dead for some time, but they have very, very valuable artistic output. And the families continue to bicker over that. Like, I think Tupac still has albums coming out, and Prince, whatever, has 100,000 albums worth of material, whatever. Prince has all this material that he never released. So we are seeing more and more disputes about people after their death, who gets to control their image and likeness. Now, this example, I don't even know how Hasbro thought they were going to get away with it. This woman on the left there is a commentator on Fox News, Harris Faulkner. Hasbro comes out with this little, I guess it's a hamster, some kind of hamster toy. They call it Harris Faulkner. They're not even calling it like Ferris Faulkner. They didn't even like change the consonants or anything. How did they not think that this was some type of privacy violation? It was. Then we have this case, which is kind of interesting. There was a TV show called Cheers many years ago. I remember it. There was two characters, the actors at the top of the screen here, Cliff and Norm, were the two characters who would sit at the end of a bar. Cheers was set in a bar. Frasier was a spinoff from Cheers. Okay. They would sit at the end of the bar and they would always tell jokes to one another. So some company decides to open a chain of bars in airports. There's always bars in airports. And apparently there's also this belief that no matter what time of day it is at the airport, it's okay to drink because you're in this kind of liminal space. Anyway, but I digress. So they're going to open a chain of airport bars called Cheers, and there's going to be these two animatronic robots sitting at the edge of the bar. Those animatronic robots are showed here on the screen. Those are the two bottom characters right there. Well, apparently, when the company that's opening the animatronic bars is licensing the property, they didn't get the right to use the likenesses of the actors. And I'm going to guess here, I'm just going out on a limb, I'm going to guess here when the contract was signed by these actors many years ago for Cheers, could have been in the 1980s, maybe there wasn't a clause there that said you are giving up your likeness for animatronic robots in the future. No one foresaw that being a potential licensing opportunity for the show. So anyway, I'm sure the company that opens these bars thinks that they've licensed the property correctly because they did have a deal with the studio. But the actors were, and the lawsuit went back and forth for years. The actors were able to sue that even though the robots didn't really look physically like them very much, that it was clear that for anyone who's seen the show, those two robots sitting at the end of the bar telling jokes were supposed to be Cliff and Norm. I don't know what the outcome was of this, to be honest, but it was in the news quite a bit, and it's come back in the news with the growth of AI and things. but yeah, it's kind of a cautionary tale. Just because you're licensing some property and you want to use someone's image or likeness, a famous person's image or likeness, you got to be super careful that you have all the rights to do that. Here are some different defenses if you are accused of appropriating someone's image. These terms come from the textbook, they're in the lecture notes, y'all can read. Here is a case, this is discussed in the textbook. What page is this on? At one point during this three-way tag team wrestling match, one of the teams actually walked over, bought some nachos, and then they had a whole shtick where they were eating the nachos and giving the nachos to the people in the audience. People were screaming and yelling and really getting into it. It was just overall a splendid, splendid little form of twisted theater. And one of the matches that we saw took place almost entirely outside of the ring. I'm going to include some of the video of that right here. It was way harder than it needed to be to turn the page. Yeah, it's on the bottom of page 274. There's a character. He was a hockey player known as Tony Twist. He was what's called an enforcer. An enforcer in hockey is the person who, like, if you bump one of their teammates, he's going to come over and smash you in the face. He's kind of like I wouldn't say bully, but he's an enforcer, as the name would suggest. He appears in a comic book. Todd McFarlane. Is it McFarlane? Does it say who copied him? Doesn't say. Okay, yeah, I think it was Todd McFarlane. Copies the character Tony Twist and puts him in a comic book as an enforcer, claiming this is a transformative use, that I've transformed. That doesn't really feel that transformative. I think that the comic book publishers lost that case. And then we have, there was a different outcome here. Yeah, this was a different outcome here. Johnny and Edgar Winter are two albino musicians, and they appear in Jonah Heck's comic book, not as the Winter Brothers, as the Autumn Brothers. There they are right there, the Autumn Brothers. And this time, the courts found that was a transformative use. So Tony Twist wasn't a transformative use with the comic books. The Autumn Brothers, who were based on the Winter Brothers and Jonah Hex, that is a transformative use. I don't know, the rhyme or reason here. I think it usually depends on who has the best lawyer in these kind of cases. I'm going to pause here for a moment just to show off some of my Jonah Hex comic books, because I need an academic justification for all the money I'm spending on comic books. Arsenault's Jonah Hex. Okay, here are some of the Jonah Hex comic books that I have. And this is not Jonah Hex. This is a Portuguese Bonanza comic. Yeah, okay. This is Weird Western Tales Presents Jonah Hex. I have 3 of these. That's a nice cover there. And then we have the Jonah Hex. I have quite a few of these. And some of these have really excellent covers there. Oh yeah, look at this one. That's, what is that? That's number 19. That's a really nice cover there. And then there's another one that I have. Oh, that's a great cover. Look at that. Okay. And yeah, this one right here, number 49. Yeah, I mean, I have a pretty trashed copy of that. But anyway, those are some Jonah Hex comic books. Okay, now we have private facts. Basically, if there's something about some intimate facts that you wouldn't want the community to know, and that gets publicized, you could have grounds to, say your privacy has been violated. Okay. The case, this is discussed in the textbook. Where is this in the textbook? Okay, now we have this case. This is in the textbook on page 279. I'm laughing because it's such a sordid case. Hulk Hogan has relations with a woman who's married to another man. I guess the guy used to be one of these shock jock DJs, called himself Bubba the Love Sponge. I think is that what his name was? Anyway, he records, I'm laughing because it's so bizarre. He records Hulk Hogan having relations with his wife, Bubba the Love Sponge wife. And then he releases part of the tape, or someone releases part of the tape, and they're claiming that because Hulk Hogan is a public figure and he talks about so much stuff in public, that there's like it's okay because it's newsworthy. And then here we have, this is like an image. Someone's having some fun with the release of a Hulk Hogan sex tape. Anyway, you get the sense of what's going on there. Yeah, this is talked about in the textbook on page 279. What happened was Gawker, the website or the news outlet that published the sex tape or an excerpt of the sex tape, went bankrupt. They were driven bankrupt by this. Now, what I find unusual is that you might say, okay, they should go bankrupt. They published this, not humiliating, but they published some very embarrassing information about Hulk Hogan that wasn't newsworthy. They deserved to get sued into bankruptcy. Peter Thiel, this big Silicon Valley billionaire, who was one of the founders of PayPal, was an outside investor in Facebook. He's still active. He had it out for Gawker, and he was bankrolling Hulk Hogan's case. Because Gawker had published some information about him that wasn't illegal, didn't cross the line, but he didn't like Gawker doing critical stories about him. So he found a reason that he could drive Gawker into bankruptcy, and he was able to do so. Although, yeah, I do think that they did violate Hulk Hogan's privacy. Anyway, that case is in the textbook. And then we have this very famous incident of someone's privacy being violated. A guy named Oliver Sipple saved the life of President Ford, Gerald Ford, only president never elected. He was appointed to vice president when Spiro Agnew had to resign, and then he got to be president when Nixon stepped down. So anyway, woman is going to shoot President Ford. Oliver Sipple, who was a former Marine, reaches out, hits the woman's arm, saves the life of the president. However, the reports about him mention that he was a former Marine. That does seem relevant to the story. He knows how to handle himself under pressure. He was also gay, but he wasn't out. Okay. And the articles about him revealed that he was gay. He said this was very embarrassing because he hadn't come out to his family yet. Now, I don't know what your feelings are about all of these things. Okay. LGBTQ, that whole realm of things. I don't know what your feelings are, but it could be very embarrassing for someone to come out today in the 2020s. You have to imagine that in the 1970s, it could be even more potentially damaging or controversial, and people should have the right to make that decision for themselves. This thing was in lawsuits for years, and I don't think Sipple was able to win. If he did win anything, it wasn't much, and it took him forever. It just like plagued the rest of his life, the lawsuits over this case. The journalist's argument was that you went to some gay bars, and then therefore that's you acknowledging publicly. I don't think sneaking around and maybe going to a gay bar, in the 1970s, presumably is the same as walking down the street with a pride flag on, screaming for the whole world to see. So I don't think he really was that out. But anyway, yeah, the very famous case, kind of a textbook example of revealing information. The journalist had that information. Maybe it wasn't illegal to publish that information, but I don't think it was relevant to the story. And here are the different defenses that you can use if you are accused of revealing private facts about someone. You can take a look at this in the textbook. And then finally, we're going to end with some discussion about all these, the world of privacy is just incredibly twisted and difficult and challenging in the modern era because of, what am I looking for? Because of new technologies. They record things. I mentioned smart speakers. Whenever you go to a website, you're being tracked. We're constantly being asked, do you want to accept cookies? Do you not want to accept cookies? The Federal Trade Commission is the organization that is in charge with protecting consumer privacy and enforcing federal privacy laws. And I'll say this, Spokio Inc. v. Robbins. That's a court case on page 286. If that's not in the study guide, it should be in the study guide. That is a relevant case here, and you should be familiar with the gist of that case. Okay, we've left the wrestling. We watched about an hour and a half. There was an intermission. I was ready to stay. Imran was ready to leave.
I was getting tired.
What did you think of it, Imran? What was your reaction?
That was good. I will say at the beginning it was not good.
And then it got better?
It got better, and then it was starting to go downhill. So I was like,
But what we're trying to figure out is, like, how much money could they have made from that? At most, there was maybe 100 people there, maybe a little more than 100. We paid 20 bucks each. Let's assume everyone paid 20 bucks each. That's $2,000. Some were little kids who didn't have to pay 20 bucks. And then some people maybe got in free, but let's just conservatively be generous and let's say they made $2,000 at the door. There must have been like 20 people wrestling, including like people who were like the faux managers, who were also characters, who also got involved with the fighting. Right, Imran? You think there's about 20 people fighting? So if the concession stand people, we tried to figure this out, if the concession stand people didn't make any money, if they just made money based on the concessions they sold, the wrestlers maybe got 100 bucks each at most, or maybe some wrestlers got more and some only got like 50 bucks. I don't think these people are making money from this. This is clearly a labor of love. But what do you think, Imran? Do you think they want to be professional wrestlers, or they're just doing this for kicks?
They might just be doing it for kicks. That would be my guess.
Yeah. Anyway, I just ordered a California burrito. What did you get, Imran?
Get some tacos.
2 tacos. All right. So we're waiting for our food, but that was actually a fun night out, watching probably the lowest rung of professional wrestling that there is, WWZ wrestling. That's what we did. Okay, that's it for the privacy lecture. Now you understand why I put the wrestling video in there, okay?